Good morning, everyone. Welcome to the Michigan Hall of Justice for our November case call. Our first case this morning is 3M versus Department of Environment, Great Lakes, and Energy. This is a 15-minute mini oral argument on the application. You may reserve time for rebuttal, but we ask that you try to keep track of that time yourself. You both have a free fire zone, which you may waive, and you may begin when you're ready.
Good morning. Assistant Attorney General Richard Cole, appearing on behalf of the Appellant, Michigan Department of Environment, Great Lakes, and Energy, which I'll be referring today by its acronym, EAGLE. I'm also honored to be with Solicitor General Ann Sherman, who has joined me at Council's table today. I'd like to reserve 3 minutes of my time for rebuttal. Madam Chief Justice, may it please the Court, the question presented today arises out of EAGLE's attempt to establish new rules limiting the permissible levels of poly and perfluoroalkyl substances, otherwise known as PFAS, in drinking water. Agencies promulgating rules are required under Section 45 of the Administrative Procedures Act to prepare a regulatory impact statement. The key language in this appeal was found at subsection 3N. The Act was recently amended, so it's now at subsection 3L. That subsection requires agencies to estimate the actual statewide compliance costs of the proposed rules. EAGLE's proposed rule sets established maximum contaminant levels for PFAS in drinking water under the Safe Drinking Water Act. EAGLE provided detailed estimates of costs that would be incurred under the Safe Drinking Water Act and therefore complied with the plain language of the APA. Now, our position that the proposed rule means the rule set at issue and nothing more is supported by 3 opinions of this Court, cited in our brief, that have held that the word "the" has a specific limiting meaning. And under that precedent, the proposed rule means the proposed drinking water amendments. Despite expressly acknowledging the plain language of the statute, the majority below declared that it would instead look to the entirety of the statute to find that cost estimates should not just be limited to the proposed rule, but should also include any other rule impacted by the amendments.
Counsel, has this happened in other states?
It's my understanding that New Jersey, in fact, addressed a very similar claim by 3M in its court. And in that case, the court found that it focused more on whether or not an agency could be silent, whether or not it had to address all potential ripple effects of a rule, and it found that it did not. So yes, it has been addressed before.
And it seems to be specific to 3M as well?
That case was 3M. I believe in some of the amici briefs, they went a little further abroad than in the state, and they had found several other cases, I believe also from the D.C. Circuit, which frequently handles administrative appeals for the federal government, where they also found that they had approved agencies being silent in certain circumstances.
Thank you.
Counsel, I found it interesting. I thought the Great Lakes Environmental Center raised some important issues that maybe haven't been directly argued by the parties, but we've got this argument about mootness, and we've also got this argument about failure to exhaust administrative remedies. I thought I'd start with the failure to exhaust administrative remedies. What are we to do with that? And I'm wondering why that wasn't raised below.
Well, I think they are important issues. Before the Court of the Claims, we did address standing, and we did raise both of the issues that the amici had addressed. The court ruled against us, and we did not include it as part of our appeal, and it's not part of the issue today. However, it's clear that they have raised important issues, and we think, in fact, that there is a significant standing question, and we would be happy to address it if the court would like further briefing on the issue.
Thank you. Oh, okay, let's turn to mootness. What do we do now that the groundwater rules, as of now, they've been separated more or less? So what are we to do with that?
To me, the mootness issue really goes over into standing. They're almost one and the same thing. And I think because the drinking water rules no longer establish the groundwater contamination standards, and that's because the division responsible for groundwater contamination promulgated its own rules establishing separate criteria for PFAS.
So
And
if
so
we-
it's those rules which will now govern.
So if we were to agree with you, does that make this case moot?
Yes.
Okay. And so the proper remedy then would be to vacate the lower court rulings?
That's correct.
Thank you.
So can we get to the contention of that it was, you know, that the APA requires the statement to really only address an estimate of the compliance costs of the rule, right? And not going this sort of, whether it's, you know, an outer ring of the next sort of thing or the next sort of thing or what have you. And I understand that argument of, you know, that we need to construe the APA such that, you know, that that the agency is only required to include things that are actually in compliance with it. But what do we do with the fact that in this case, the statute, the Part 201 cleanup statute, right? So if 3M or some other entity has a contaminated site, their facility, they need to clean their standards up to Part 201 standards. And under Part 201, they say, you know, specifically in the statute references this cleanup rule. So why is it really going, you know, sort of outside that first ring of impact to say that that a business or a person who is going to have to comply with the rule is going to incur consequences or compliance with Part 201? And putting aside the fact of whether you can or should or how you would estimate what that cost would be, you know, which is a different question. Why is the fact that the statute that needs to be complied with actually references and ties itself to the rule? Why is that not a proper consideration?
And I think the answer to that question, which really kind of goes to the heart of this, is Section 45, 3L only requires an estimate for the proposed rule. And the proposed rule set at issue is the drinking water standard. So under that plain language, we don't believe that an agency had to go into ripple or secondary effects. And frankly, there's good reasons for that. The legislature declared it, and we're here to apply the legislature's language. We think that is the plain meaning. But if you understand how state government works, it makes sense. You know, state agencies are these large entities made up of multiple divisions. EGLE's a good example. EGLE has multiple divisions, each responsible for its own environmental issues. They're expert in that individual area, but they're not an expert in all the other areas. We know there can be overlap. We know that the drinking water might establish groundwater, and the groundwater standards might apply to solid waste disposal sites or leaking underground storage tanks. And overlap might even extend into other departments. For example, we know that OSHA standards to protect firefighters adopt criteria set by EGLE for PFASs. And the point is, these divisions are experts in their area. And that's it.
Well, but
water.
here's the difference, though, and I get the point that you're making, is that to comply with the cleanup standards, if an entity has to comply with the cleanup standards, that cleanup standard is specifically referenced in Part 201 as the drinking water standard, if it is, you know, more restrictive, or the federal standards, which have also, I mean, that goes to the mootness, right? They're going to be subject to these other standards now, regardless maybe of what we do. But I think, isn't that a difference than, say, like OSHA? Well, sure, there may be other things out there where you're going to have other consequences of it, but when the statute specifically references the rule and you would have to comply with the rule under a Part 201 cleanup, you know, remedial action plan, why is that not still a sufficient causal, you know, when it specifically references it? I get it doesn't reference OSHA or some other standard, but it specifically references those drinking water standards.
And I think our position is very simple on this, which is that the language selected by the legislature says you're only obligated to provide estimates of compliance costs for the proposed rule. And the proposed rule set at issue established maximum contaminant levels for PFAS in drinking water. I think that simply stated is our position on that issue.
And counsel, is this a one-off that these are linked? You referred to some other, I'm just sort of the ramifications, if we were to agree with the 3M position, would we now have to have, every time, there's a proposal for a rule change, search every statute and every rule to make sure there's not a link? I mean, is it common for rules to be linked together, is what I'm wondering?
In my experience, I would not say that it is common. It certainly does happen, as I gave some examples of where it happened, and I know there are some other examples, but I don't think it's common, so it would probably be an unusual situation for it to arise.
Okay. I have another question I don't know if you know the answer to, but the rules, I know we've had no stricter than federal, and so we've had changes, I assume, based on federal changes over the last, let's say, 15, 20 years. Has there ever been a need to, were there regulatory impact statements based on those changes?
Yes.
Okay, and I assume there wasn't then a link to a like groundwater regulatory impact statement?
I have not gone back that far, and so I can't answer that question.
Okay, thank you. I was just curious, and I know you maybe wouldn't know the answer, but I appreciate that. Thank you.
So, can you clarify, the sort of real-world consequences? If we were to uphold the lower courts having invalidated the drinking water standards, it may very likely not impact 3M or other potential people who would have contaminated sites that have to clean up to groundwater standards and or the federal standards. But what it would do if we invalidate the drinking water standards is that public water supplies now would not be required. And we would have, 3M doesn't have sort of a dog in that race, right?
Correct.
But municipalities, those that are providing the public water source to the public, would no longer be required to comply with standards that anybody cleaning up a site would actually do. I mean, isn't that a
Correct.
little...
The real impact of a decision upholding the blow decision would be that, Eagle put these maximum contaminant levels in place to protect the public from this toxin. It is much more toxic now than we believed to be just several years ago. And so those protections, the protections that are protecting the public, would go away.
For public water supplies?
That's correct.
For a period of time. I mean,
Correct.
there's
Yes.
federal regulations that are...
They would have to take action to somehow bring new standards into effect, which would take time.
The real-life consequences would be that this would become, could this be seen as dangerous?
Yes, we believe this toxin has significant negative health impacts. And so if water supplies no longer have to comply with the maximum contaminant levels, then individuals could be exposed to it. I mean, that's why Eagle first started PFAS regulations with drinking water, because people use drinking water on a daily basis and therefore are potentially exposed to any contaminants with it on a daily basis. That's why they started with drinking water. That's why these rules are important, and we believe that you should find that the underlying court erred by not applying the plain language of the section. You should accept the application, and that you should overturn the Blow opinion. Unless you have any questions, I'll turn the podium over to my colleagues from 3M.
Thank you.
Thank you.
Thank you. Good morning, Chief Justice. May it please the court. My name is Nessa Coppinger. I'm arguing today on behalf of Appellee 3M, and I'm here today with Amy Johnston, who's at council table with me. This case involves a narrow and straightforward finding that Eagle must adhere to the requirements of the Michigan Administrative Procedure Act during the rulemaking process, and that it failed to do so in the specific circumstances presented here. This unremarkable finding, applicable in extremely limited, if not unique circumstances, does not merit this court's review. It does not involve a legal principle of major significance to the state's jurisprudence, and Eagle has not established grounds for review under MCR 7.305B. If the court does undertake review of the Court of Appeals decision, it should be affirmed. To find otherwise would condone Eagle's decision to ignore the legislature's unequivocal mandate in the APA that an APA-required regulatory impact statement must contain an estimate of the actual statewide compliance costs of its proposed rules. The court's case law, including Michigan Charitable Gaming, Detroit Base Coalition, and Rovus, make clear that Eagle's knowing decision to disregard the procedural requirements of the APA and omit an entire category of costs from the regulatory impact statement is entitled to no deference and invalidates the rule. There are 3 key points, all of which are undisputed, that make clear the ruling should be affirmed. First, there is only one rulemaking for PFOA and PFOS. There is no other, as Eagle claims. Second, the regulatory impact statement that went to the public did not mention groundwater cleanup costs for PFOA and PFOS at all. The draft that Eagle prepared did include those costs, and Eagle removed reference to that before it went to the public. Third, there's nothing in the record that supports Eagle's claim that it could not make an estimate.
Is it possible for there to be costs that results from a rule that are not actual compliance costs of the rule that need to be estimated in the regulated impact statement?
I'm sorry, the question...
Is it possible for there to be costs that result from the rule that are not actual compliance costs, is that term's used in the statute, yes, that need to be estimated in the RIS? Is it possible?
It is possible. It is possible. There are other aspects of the Administrative Procedure Act requirements for a regulatory impact statement that may not fall under this specific directive, which, as my colleague noted, used to be subpart N, but now is L.
So how do we draw the line between what needs to be estimated in the RIS and those that don't? What's the limiting principle that we should come up with, applicable not just to this case, but all the other cases we see?
Right. So there's been a lot of discussion in the briefing and in the lower court about direct versus these sort of ripple effect so-called costs or indirect costs. The direct costs of the rule are those that come into place because there is no more legal or other action that is required before those costs must be undertaken as compliance costs. Here, Eagle has said itself that these are costs of the rule. They said that in the draft RIS that did not go to the public. That's the exact language, the rule. And they also acknowledged initially that those were costs of the rule. It's Eagle's own choice that it made to decide that it need not address these costs because it said, well, we'll deal with them later. But here, there is no later. There is only one rulemaking. And to address briefly the mootness point, this case would not be moot. This case is not moot by the adoption of under a separate rulemaking related to 5 of the 7 PFAS. There is no separate rulemaking for PFOA and PFOS. And so these are direct costs of this rule, and that is also why it is not moot at this point, because there is no other rulemaking.
So why, if 3M is required to, has a facility, has to clean up, has to comply with a remedial action plan that gets established, why is 3M's compliance not with the statute of Part 201 as opposed to complying with the drinking water rule? You're not in theory complying with the rule. You have to comply with the standards established in the statute under Part 201. Why is that not a sufficient sort of dividing line between saying you're not complying with drinking water standards, you're not a public water supply, you're not required to comply with those? Yes, it's referenced in them when the department is deciding what you have to comply with, but their authority to require you to comply with cleanup standards is under a statute, Part 201, and not the rule.
The standard, Part 201 does not adopt specific standards. It creates the process and directs how those standards are implemented and adopted, but the standard itself is the drinking water standard. That's what Part 201 says.
Well, couldn't the department, I mean, under sub 4, right, they establish under 324.201.20A, under 4, it provides a criteria for establishing whatever particular standard needs to be complied to in a particular site, right? And it's highly variable depending upon what the aquifer's like, how long, you know, all of these things. They establish that, and it's only if, I mean, could they establish a standard that's actually more restrictive than the drinking water standard?
No, they cannot. If the groundwater, for substances where there has already been a groundwater criteria set, so in this case, that was PFOA and PFOS, but not the other 5 substances that are the subject of the rule. Where groundwater criteria has already been set and subsequently a drinking water standard is put into place, that drinking water standard automatically supersedes whatever existing groundwater criteria there was and becomes the standard. The agency does not have discretion at that point to set a different standard for those groundwater criteria.
It can't go backwards. It can't set the drinking water and then go back in for the groundwater.
Correct. That's correct.
Do you necessarily, does every site have to be cleaned up to that level?
There
What if you have
are-
a non-potable aquifer? What if you have something that, you know, there's no migration, there's no, like the department and everybody determines that this is not actually at risk of contaminating either groundwater or potentially getting into a drinking water supply, even if those levels happen to be higher. Is it automatic that even that type of site or even that type of facility has to be cleaned up to those standards?
So there are, the Part 201 standards, the automatic change that we're talking about is to the general standard, right? And,
Sure.
and you're talking about site-specific cleanups, which may deviate from the general standard because of site-specific conditions like what you're talking about. So I think the answer to your question is yes, it can be different in specific circumstances. One of the fundamental issues with what happened here is that the agency said nothing about any of this in the regulatory impact statement.
So there could be a site that does not, in fact, have to comply, even with PFAS, in excess of the levels established. There could be a site owner or an individual who doesn't, in fact, have to comply with Part 201 by reference then to the drinking water standards. Because they don't, a compliance cost. They don't have to incur costs to clean up their site to comply with that. Is there some other compliance cost that they would incur other than having to clean up for this like hypothetical site or individual business that doesn't in fact have to comply with those standards because they don't have to clean their site up to that?
So there may be site-specific circumstances where, for example, there are no risk receptors, right? There's no drinking water wells. There's nothing that is going to create a risk of exposure at levels of concern. So that could be a site-specific outcome here. I think the issue we have is not necessarily that there are circumstances where a site, there may be site-specific cleanups or not cleanups based on the particular circumstance of the site. The point is that there is a direct and automatic change to the general cleanup standards.
But we're looking at what is like the compliance costs. Is there some other compliance cost that we're talking about other than having to comply with a cleanup standard? So most people, or maybe most sites may in fact have to comply with this drinking water rule because of its inclusion in 201. But there may be, as you said, there may be a site-specific sort of circumstance where that person or business doesn't in fact doesn't incur compliance costs.
Right.
Because they're not having to clean up. Is there some other category of compliance costs that like we're not sort of thinking of, or are we only in this realm of having facility having to comply with bringing their groundwater standards to.
So for purposes of this appeal, those are the costs that we are
Okay.
concerned about. There's not some other
Right.
world of sort of unidentified costs that we're talking about. And I think, just to reiterate, I think the point is that Eagle needed to say something about this in the RIS. What they needed to say was, maybe what they needed to say was there are site-specific circumstances where there may be no cleanup costs incurred, or there may be circumstances where there are cleanup costs incurred because the general standard applies, or the site-specific criteria would adopt the general standard. And here are the factors that would go into what that estimate would look like.
So they would have to do that for every single site before this could go into place?
No. They don't have to do it for every single site, just like they don't have to do it for every single site for the drinking water providers who have to test and treat their drinking water. They don't do sort of an individualized analysis for those either. What they do is they say, here's, an average cost for this kind of circumstance, this amount of water. It's the same idea for the groundwater cleanup standards, where they do have an entire department dedicated to remediation in the state. They identified in the press releases for this the number of sites that they thought would be at issue. All they needed to do was say something about that and say, there's this number of sites, there may be more, that may not be an exact precise number, but we know that this is sort of the minimum of what we're looking at. There may be site-specific conditions that affect the cost, but here's, an average cost for this type of remediation, or here's, here's how much it costs for the one site that we know about, and if you extrapolate that to 50% of the sites that we have already identified, here's an estimate.
Of course, their argument then is then they're at risk of wandering into the arbitrary and capricious territory, right?
Right.
Where they're, saying we have 54 sites, and, you could range from the lowest to the highest cleanup costs, and obviously it's going to be site-specific and dependent on XYZ, but, at some point, their contention is, without actually being able to get any closer than that's arbitrary and capricious, but you don't think that would put them in that territory?
I do not. I mean, the APA does not require that level of precision down to, the exact cent or the exact number of sites. What it does require is the agency to exercise its reasoned judgment.
Okay, can I ask, has your client or anybody else, I guess to your knowledge, have they filed an action challenging the groundwater cleanup rules as invalid?
No.
So would you agree that whatever we do or to the drinking water standards, under Part 201, the groundwater standards are going to control, maybe other than perhaps with respect to these two analytes that you're talking about, but either the federal standards or the already existing groundwater standards are going to apply to your client?
I think the way you said it is exactly right. For the 5 substances for which there was a separate rulemaking to establish the groundwater cleanup standards, those, if this rule is invalidated, those standards would remain in place as groundwater cleanup standards because it was a separate rulemaking. There are no separate standards that were adopted. There's no separate rulemaking for PFOA and PFOS.
Okay.
Counsel, I just wanted to ask, so it's your position the entire rule should be invalidated, but the statute I read, it doesn't seem to require invalidation for failure to comply with the create the regulatory impact statement. It cites other things that would require invalidation, but that's not one of them. So I'm just wondering, is invalidation the only remedy here?
I think it is the appropriate remedy, but if you're asking me if the court could do something sort of lesser than invalidate the rule, I think it is possible that the court could, remand to the agency for consideration. I will note that it has been about 4 years that this has been working its way, and the agency could have corrected this at essentially any time and has not done so. So that may be a possible outcome.
And I'm going to ask you the same question I asked the Attorney General's office. What are we to do with sort of the failure to exhaust administrative remedies here? There are lower court decisions that basically state that, there's no jurisdiction in the Court of Claims if administrative remedies were not exhausted. I know case law is a little bit all over the place on this. We have not directly weighed in, but I'm wondering what your thoughts are.
I'm actually glad you asked, so I have an opportunity to respond to that. Failure to exhaust administrative remedies is not relevant here. There's 2 reasons. One, first of all, it was not raised in the lower court. I understand that, the court may want to sua sponte address it in any case. In that case, where the validity of a rule is at issue, there is no requirement to exhaust administrative remedies. And that makes good sense, right? Because the agency adopted the rule, there's a public comment process on the validity of the rule, where presumably the idea is that concerns are raised, the agency has an opportunity to address them. And so requiring someone who's challenging the rule to go back then to the agency and say, hey, this rule that you just passed that I just told you what I think is wrong with it, could you reconsider that? That doesn't make a lot of sense. And so I think the cases that talk about failure to exhaust administrative remedies do not talk about the challenges to the validity of a rule. They talk about challenges to the application of a rule.
Thank you.
You're essentially saying futility.
Yes.
Right, there's case law out there about exhaustion.
Correct.
It's not necessary when it's futile.
Correct. That's right. My time is up, so unless you have any further questions, thank you.
Thank you.
Appreciate your time.
Thank you. I'll just briefly respond. This is a significant issue. Public health is at issue. It is always a significant issue. And so we do believe that there is a good reason why this court should accept this application. One of the questions that you raised, sir, was, what is the standard? And I think that's important, because if you look at the topics in our regulatory impact statement, they're all very broadly stated. And every agency is drawing a line as to what should or should not be included in responding to each of those topics. Well, how do they know what they have to include? And that's the key, and why we need to have a standard set. And if the standard set by the legislature is what the amendments are required, cost estimates required by the proposed rule.
All right, so the statute actually uses the word actual.
It does.
And I'm getting a little stuck on that. And
It-
it's a occupational disease I have, getting stuck on words. Actual statewide compliance costs. And Eagle was asked repeatedly to look at it, and they didn't go to the actual cost. They just looked at the rule cost, not the statewide impact.
Well,
how do we give meaning to actual? It could have easily said statewide compliance costs relating to the rule.
Yeah, if you look at the language, it requires estimates of actual statewide compliance costs. How can you have estimates of actual costs? But you're right. I mean, that goes to the heart of the problem. Actual means concrete, definite, real. And the fact of the matter is, under the legislation, for Part 201, Eagle couldn't know those costs, because not all sites had to be reported, and costs that entities are using to bring themselves into compliance don't have to be reported. So they don't know, in fact, what the actual statewide costs are. There's no dispute about that. They can make guesstimates, but then you're getting into the arbitrary and capricious standard.
Can I ask one question, just to ask you to address this question of, as your opposing counsel said, that the drinking water, this rule promulgation is the only rulemaking that addressed PFOA and PFOS. But is it my understanding is that there were existing standards for PFOA and PFOS, correct? And so those were already in existence before this rulemaking, and it was only the additional 5 analytes that actually needed it. There were existing groundwater
There were
cleanup
existing
standards.
groundwater criteria for 2 of the analytes. They had been issued many years before, and so we're at a much higher level. And it's because we've learned how toxic PFAS are that we've significantly reduced the maximum contaminant levels. So yes, there were old standards, and it's because the drinking water standards were much lower that those, at least for a time being, controlled what the groundwater standards were going to be.
When you had those prior groundwater standards, did the department have to do estimated costs then?
I can't say. I would assume so, but I
So
don't know
it's-
the answer
so
to
it's
that.
po- I mean-
Or, sorry.
Yeah, go ahead.
Those were probably criteria established by the federal government, and so they relied on the work that the federal government had done at that time. All right? I appreciate your time. Thank you very much.
Thank you.
Thank you. Case will be submitted.